What's going on, guys? My name is Mark Ruel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. On today's episode, we are going to cover evidence and how you defend yourself when you've been falsely accused in family court. So, here's one of the saddest things that I see every single day in family court. And that is men and really parents in general falsely accused of domestic violence in family court. Now, there's a few things that we need to kind of quickly cover to make sure we're on the same page. So, first of all is in family court, the domestic violence restraining order. My biggest beef is that in the state of California, the definition of domestic violence keeps expanding, both through what our Congress is doing, what our state assembly and state senate are passing, and through case law. So the definition of domestic violence is extremely broad in the state of California. We have undoubtedly the broadest domestic violence definition of any state. There are a few states that are currently fighting adding coercive control to their definition of domestic violence. Well, unfortunately, here in the state of California, we have had coercive control as part of our definition of domestic violence for over 5 years, going back to 2020. So it's been around. Number two is that with these laws and with the expansion of laws and with what being found to have perpetuated domestic violence does, it creates a situation where this tool that's designed to be used as a shield, someone is being abused, someone is being harmed, and a lot of times children are involved, and we need to protect them. And that's why this process was designed. But the way it's evolved in our current family courts is it gets used as a sword, not a shield. It's a shield to protect the abused, but it's being used as a sword to quickly gain control in family courts. This happens all over the place. We hear the term the silver bullet method, and we talk about false allegations or flimsy allegations all the time. So let's dive into evidence and what I want to use to help protect men and fathers that are wrongly accused. Number one, the hardest thing to prove in a domestic violence restraining order, the hardest thing to prove as an attorney is to prove that something did not happen. The absence of something happening or something not happening can be really, really challenging, because if the individual on the other side says he hit me or she shoved me or she chased me with a knife, if it never happened, there's going to be no evidence of that. And in family court, it's not like criminal courts. If you get charged with criminal domestic violence, the burden of proof of the prosecution is beyond reasonable doubt. It's a very high standard. You're going to have to find a jury of peers that say beyond reasonable doubt this action occurred. In family court, it's completely different. It's preponderance of the evidence. It is 50% and one feather. Whichever side is more believable, the judge can rule in their favor. And I talk about this a lot, that a lot of times when it is those toss-up cases or it's flimsy allegations, it's safer for the judge to grant a short-term restraining order than it is to deny one, and then something happens and they're in the paper the next day for having denied this individual restraining order, and then they get harmed or even killed. So I like to say it's like we have to get to a point when we're defending restraining orders that the other side cannot be trusted. So number one, the biggest pieces of evidence I'm going to look for. The other side's going to put their case on first. And the first thing we are going to want to do is punch holes in their credibility. Now, this can be done in one of two ways. The first way, and usually the most effective way, is on cross-examination. So they go first, they put their case on, and her attorney is going to ask her a set of questions, walk her through what's happened and why a restraining order is needed. Well, as the attorney defending the restraining order, I want to immediately go in and punch holes in their story. make them seem less credible. One of the craziest situations I've ever come across in family court is we had an individual who was facing a restraining order, and the other side claimed that they had photos of strangulation, that our client had strangled her. Our client said, no, that never happened, that didn't occur, and we start digging in. And somehow, some way, our client brings us screenshots of a chat between her and her affair partner. And in these chats was that same photo, that photo of her neck with the mark on her neck. But in these photos with her affair partner, they went a little bit further south. They went all the way down to her waist, and she wasn't wearing any clothes. So her breasts are exposed in this chat, and she's joking back and forth about how he gave her a hickey. So we were able to ask her a line of questions, show her the beginnings of the chat, and walk right up to the point of where this photo would be shown in open court. And we actually got her to admit, yeah, that I was joking in that chat. I was talking to my affair partner, and I did tell him that that was a hickey from him. We were immediately able to just destroy her credibility. In less obvious situations, we can attack timelines. I've had situations where one party accuses the other of driving by their house, and our client was a truck driver. And I actually got him to give us his logs of where he was, and I pinned her down to a specific date that he drove by and he was harassing her and he was doing these things. And then I was able to put him on the stand and have him testify to his work records that show on that date he was actually in Salt Lake City, Utah. So immediately kills her credibility of what she's saying happened. So we're going to punch holes in the story. We're going to make them seem less and less credible. Because unfortunately, if she says, hey, he strangled me, and there's no photos, there's no videos, there's no recordings, there's no anything, well, it's going to be really, really hard for us to prove it, and it's going to come down to a credibility contest. And we want to remove the threat of a restraining order getting granted based solely on the judge's view on credibility. The second piece that with evidence that we always preach to our clients, that I talk about this all the time, unless you have dueling restraining orders, this is a one-way hearing. Now, I think a lot of situations, there's usually some sort of mutual argument, some sort of mutual disagreement, and a dueling restraining order may make sense in terms of evening the playing field. But in situations where it's just she's filed for a restraining order against you, evidence of other acts of domestic violence against you can be irrelevant in a lot of instances. Now, if we have evidence that she was the aggressor, this is a big one. So if she's alleging this incident occurred and you did X, Y, and Z to her and these things happened, but we have the Ring doorbell camera and it was recording, or it caught some timestamps of people leaving the house, or I've even had extreme situations where a person walks outside and talks on the phone and basically says, I got him. This can be really, really big, but just pointing out random acts that might be domestic violence, but she didn't allege in her request for restraining order, isn't going to be effective. If we can show that you were not the aggressor and she was the aggressor, that can be enough for the judge to say you don't get protection of a restraining order if you are the one that is initiating these issues. Now, I will say this is a little bit of a shaky one because she may be the aggressor, but that still does not give you the right or the ability to cross the line. Now, the last piece that we always like to build up in a domestic violence restraining order defense is we want to build up your credibility. And one of my favorite ways to build up credibility is what I call the 8 Mile method. And for anybody who has seen the movie 8 Mile with Eminem in it, Eminem's kind of life story, there's that final rap battle where he goes in and he's battling against a guy who's beaten him in these battles before, and the crowd's kind of with the other guy, but Eminem goes first. And Eminem goes up there, and the first thing he does is admit his faults. Talks about what has happened to him, what he has done. If there are minor things that maybe we don't think are going to tip the scales in a request for a restraining order, hey, did you send a few text messages you shouldn't? Are you remorseful? Do you regret it? Have you done things in your past? A lot of times we'll see in these restraining orders, if a guy has a criminal record or there's something that's occurred in the past, opposing counsel will beat on it and beat on it and beat on it over and over again. But you taking the stand and saying, hey, I've made mistakes in my past, I'm not perfect, I sent some text messages I shouldn't have, I wouldn't do that again, it can go a long way to building credibility with the judge, showing that you're not trying to deceive, you are just trying to get the true and correct facts out there. So those are the three big things that I look at. Number one is catching the other side in outright lies. Given that it's preponderance of the evidence, and these are credibility contests, catching them in outright lies around their statements or what they've testified to or their timelines can be extremely effective, because there is no evidence that says something didn't happen. The absence of something happening doesn't typically leave direct evidence. And then understanding that it's a one-way and understanding what types of allegations or what types of things that you may have been on the receiving end are relevant. And then lastly is, if you do have weak spots in your case, if there were mistakes made, come clean with those. Show remorse, be candid, and show the judge that you've learned from those things, and that can go a long way. Because I'll keep going back to this. This is absolutely a credibility contest. It's unfortunate. The standards need to change. The laws around DV needs to change. The process needs to change, because so many parents are so severely harmed by this shield of a process, the domestic violence restraining order process, being used as a sword. But if you take these three tips and you focus on them and you stay on topic, it can go a long way in getting a good outcome in your domestic violence restraining order. Hope you guys found this helpful. I hope you found it educational. I hope you can utilize some of this in your court hearings if you have to deal with unfortunate situations like false allegations. I'm Mark Ruel Jr., the Father's Rights Attorney, and we'll see you again on another episode of the Father's Rights Playbook.